on now to part 2 of Title 3 on the matter of the Board of Directors, Trustees, and Corporate Officers. We start with Section 23 for this part and we'll end until Section 34. So let's get started and let's move to the manner of electing members of the board. Now that we have discussed the qualifications, let us briefly jump through some provisions and move on to the disqualifications so that it's a continuous discussion, no, and a good flow of the topics. Under Section 26, there are three types of disqualifications here. Now, please note, number one, that Section 26 has a time limit. The disqualification will only apply if such happened within 5 years prior to the election or appointment of the director, trustee, or officer. Before kasi it used to be perpetual. Number two, please note that Section 26 is not an exclusive list of disqualifications. I will not read anymore what is under letter A, B, and C of Section 26 in front of your screen because this is fairly self-explanatory. The last paragraph states that the foregoing is without prejudice to other disqualifications, as I've mentioned, and these qualifications or disqualifications may be imposed by the Commission or the SEC or the Philippine Competition Commission. Now, please add that other disqualifications may be the reverse of the qualifications we've already discussed. What do I mean? If you remember, a director must be an owner of a share, at least one. Therefore, if they do not have one share and that person is not a stockholder, automatically they are disqualified from being a director or trustee. Another one, any qualification or disqualification that the corporation may impose through its articles of incorporation or bylaws. Why are there too many disqualifications before I continue with that? Well, it's because the position of a director of a corporation is a position of trust. Okay, so what can these disqualifications be under articles or bylaws? There are two cases under the Supreme Court I'd like to briefly discuss. One was the case against Robina, Universal Robina Corporation, if you remember, the owner of the Gokongwei owned by the Gokongwei family rather. In that case, they disqualified a shareholder from being a director if that shareholder is a director of San Miguel Corporation. The Supreme Court actually upheld that disqualification. Why? Because it is actually to prevent conflict of interest, insider trading. So let me repeat that. The Supreme Court upheld the disqualification because such is a way to protect the corporation against conflict of interest, say inside jobs, when, say for example, to prevent competition, unfair competition in that sense, loosely put. Another Supreme Court case would be Government versus El Hogar, which is actually a 1927 case. But there, the added qualification, so why am I talking about this here under disqualification if it's a qualification? Kasi, you see, the lack of a qualification is a disqualification, diba? It's just two sides to the same coin. Under El Hogar, there the bylaws required that the holders of shares who would want to be elected and who would assume office as directors if they win would be those with paid up value of 5,000. And that 5,000 will be used as security. That is actually allowed. What about corporate governance, which is under the last paragraph here? Here, we have the 2016 Code of Corporate Governance, where the board therein can actually review and evaluate the qualification and disqualifications of board members. So where are these qualifications and disqualifications found? They're actually in the Manual on Corporate Governance. Yan. So the disqualifications under Section 26 are by operation of law. For those of you who might want to pause this video, please do go to section 160 of the Revised Corporation Code, because 160 talks about the liability of a person, director, officer, or trustee who willingly assumes office or conceals their disqualification. Here. Despite knowledge of the existence of a ground for disqualification as provided in Section 26, meaning particularly for disqualifications under Section 26, not necessarily disqualifications under the articles or the bylaws. A director, trustee, or officer willingly holds office or willfully conceals such disqualification will be fined with a penalty ranging from 10 to 200,000 at the discretion of the court. So this has to be brought to court. And shall be permanently disqualified from being a director, officer, or trustee of any corporation. So the difference between 160 and 26 is it's a perpetual disqualification and a disqualification of any corporation. Section 160 adds, if the violation is injurious or detrimental to the public, the penalty can be increased from 20 to 400,000 pesos. Yan. So, if you look at Section 160, I'll briefly discuss it so that we might not need to discuss it later on. There is actually no criminal sanction for the board who fails to remove that disqualified director or trustee. No? So, the penalty, criminal liability under Section 160 refers to the person who has that disqualification. Section 23 refers to the manner of electing members of the board. This is not a right to elect just any stockholder or member of a non-stock. It must be someone who possesses all of the qualifications and none of the disqualifications set forth in the code, and also any additional qualifications or disqualifications under the corporation's bylaws. This right is also subject to another exception, and that is when the exclusive right is reserved for holders of founder shares. Now, election can be in person or through an authorized representative who is equipped with a written proxy. In practice, the written proxy is usually attached to the notice. There is also a votation through remote communication or in absentia, and this is a new provision. Now, a corporation can have its stockholders or members vote remotely or in absentia only if it is stated in the bylaws or if it's authorized by a majority of the board, as if you look into the second paragraph. There is an exception to that, and that is if it is a corporation vested with public interest. Votation by remote communication or in absentia can be conducted even if it's not in the bylaws. A stockholder who participates through these new modes, the of remote communication and in absentia, are deemed present for purposes of quorum. The election must be made by ballot if requested. So the general rule would be votation viva voce or by voice or by raising of hand. Stockholders are entitled to vote for the number of shares of stock standing in their own names. So be careful. And that's indicated in the books of stock and transfer book of the corporation at the time fixed in the bylaws, or where the bylaws are silent at the time of election. So if it's the time fixed in the bylaws, it's usually called the record date. Normally, it is the record date is the one set because it's easier to determine who are the named stockholders or stockholders with legal title at a date prior to the actual election. It's difficult to have to verify all of them right before the meeting. So they can either vote cumulatively for one director, one stockholder, or they can distribute their votes if they this is assuming that the stockholder has more than one, no? And they can distribute it to whoever they may want to. So that is under letters A, B, and C of the third to the last paragraph of Section 23. The requirement or the limit is that the total number of votes cast shall not exceed the number of shares owned by the stockholder. And a stockholder who has delinquent stocks cannot vote. How about non-stock corporations? Unless otherwise provided in the articles or in the bylaws, members of non-stock corporations may cast as many votes as there are trustees to be elected but may not cast more than one vote for one candidate. There's no cumulative voting for non-stock corporations. So if there must be 5 members of the board of trustees, then a member can vote for 5 different people, or they can vote for less. If they are not required to vote for as many as there are. It's only saying that the maximum is 5. If no election is held, or the owners of majority of the outstanding capital stock or majority of the members are entitled to vote are not present either in person, by proxy, in absentia, or through remote communication, such meeting may be adjourned and the corporation shall proceed in accordance with Section 25. Section 25 requires, if you look into it, that it be reported, the fact of non-election is reported within 30 days to the SEC, and an election be rescheduled within 60 days from the scheduled date. Yeah. So, the reckoning point both for the 30-day period of reporting would be from the scheduled election that did not occur or occurred but not validly because there was not enough outstanding capital stock or members of the non-stock corporation. So, in that case, the SEC may summarily order an election to be made only after there is an application for such re-election. So the SEC may also need to verify if the non-holding of the election was unjustified. Because if it's justified, then it won't push through with an order to conduct another election. So the directors or trustees elected shall perform their duties as prescribed by law, rules of good corporate governance, and the bylaws of the corporation. So a corporation cannot adopt a procedure other than what is prescribed under Section 20. For instance, a requirement that a quorum must be present cannot be dispensed with. A provision that allows mere designation of directors is not allowed. Automatic membership in the board is also not allowed because it must be through election. Stockholders elect directors at large, so they cannot vote by region except non-stock corporations, because under Section 88 of the Revised Corporation Code, the right of members of any class or classes to vote for non-stock may be limited, broadened, or denied to the extent specified in the articles or the bylaws. So if there is no limitation or any change to this right, the general rule would be a member is entitled to 1 vote. So Dean Villanueva already saw a potential loophole, and that is when an authorized representative is present with a written proxy, but later on the actual stockholder votes in absentia or votes through remote communication. So we would need to wait for a case for that to happen in order for the Supreme Court to harmonize this provision. Now, not all members of the board are always elected. Another exception applies, and that is for government-owned and controlled corporations under the GOCC Governance Act of 2011. Under that law, there are appointive directors, so you can read that here, and they are appointed by the president, and there are also ex officio members. Yan. So, just read it na lang. So, some things to remember. Votation is through plurality of votes and not majority. Majority vote is not necessary. The candidates who will receive the highest number of votes shall be declared as duly elected, even if their number of votes is not the majority, as I've already mentioned. In case the number of candidates does not exceed the number of seats in the board, said candidates, provided they receive votes, can be said to have received the highest number of votes, as the law requires only plurality of votes cast at the election. So, ang daming ways to say that, no? As to quorum, it is necessary that there is a quorum, and in the absence thereof, the election shall be considered invalid. The requirement is meant to prevent railroading of election of directors. So when you say railroad, it means to force something to happen that's usually hasty and unfair. The candidate stockholder need not be present during the meeting. It is the stockholders or members who will nominate and vote that must be present. So however, the bylaws may require the physical presence of the director who will be elected. As to cumulative voting, okay, there is a formula for such, and it's this one. Yeah. So the one at the top is the formula for determining the number of shares needed to elect one director, whereas the one at the bottom from the Book of Soriano is the formula used for the number of shares needed to elect the desired number of directors. If you look at these two formulas, the only difference, aside from the letters, the only difference is the formula at the bottom is exactly as the one at the top, except instead of just S as the numerator, it is S times the desired number of directors to be elected. In a case where there are 1,000 voting shares, 5 directors to be elected, and the desired number of directors is 2, the number of shares necessary to elect the desired number of directors is 334, and that is counted as 2,000 divided by 6, or 333.33 plus 1. So why is it 2,000? Because it's 1,000 times 2. And why is it divided by 6? Because of the 5 directors to be elected plus 1. What is straight voting? Straight voting occurs when a stockholder can cast one vote per share for each candidate or director up to the number of positions to be elected. So if a stockholder has 10 shares and 5 directors are supposed to be elected, the shareholder can give 10 votes to each of the 5 candidates that he wants to elect. In cumulative voting, he can accumulate all his votes and give to one candidate all his votes, or he may divide them. There is nothing under the code that prevents stockholders from resorting to straight voting. So it's up to the stockholder how he will divide his votes. This is true even if cumulative voting is provided for under the Revised Corporation Code. Election of incomplete directors is allowed. They may still function so long as the remaining directors constitute a quorum. Why does this happen? It may be because since the candidates need not be present, later on they might decide that they are not willing to serve as directors. Or it just so happened that the stockholders did not want to elect other candidates. So for failure of election, there is section 25, which we will go over again later. Just note that if the meeting is adjourned for failure of election, that adjournment is not indefinite, or it's not sine die. What about election contests? Election contests must be filed with the regional trial court because it used to be under the SEC, so it was transferred. And these election contests cover the cases stated on the screen, numbers 1 to 5. If an election is invalid, that issue becomes moot and academic, meaning there is no more need to discuss the invalidity of election if a valid election was conducted to elect a new set of board of directors. And this usually happens when the issue of the invalidity of the old election, it takes so long, it already took a year. And since election must, there is always an annual stockholders meeting, then the election is usually held annually. If I may just add for election contests, under the interim rules of procedure for intercorporate controversies, a case is usually filed 15 days from the date of election if the bylaws do not provide for a procedure for the resolution of the controversy, or if there is a provision under the bylaws as to how election contests will be resolved, a case can be filed with RTC within 15 days from the resolution of the controversy following the procedure under the bylaws. And it must be that the plaintiff or the one filing the case has exhausted all intracorporate remedies provided for in the bylaws. I would like to read to you some questions that were asked of the SEC, where the SEC stated that the provision is invalid. Number 1, shares in the Articles of Incorporation, it says there that shares are classified as Class A and Class B, where Class A is entitled to 1 vote and Class B is entitled to 3 votes. So that is not acceptable. Another invalid provision is where Class A shares are entitled to vote 1 director and Class B shares voting as a separate class shall be entitled to vote 3 directors. And it is contrary to Section 23 of the Revised Corporation Code. So you might be wondering bakit ako pabago-bago ng damit. It's because I am actually cutting and pasting this video. I'm actually reading the provisions in 3 books, so I know that the flow is continuous, as I don't expect you to read it much like how I did in law school, and reading it provision per provision. At least this way, it's easier to understand, to prepare you for your board and your quiz and midterms. Okay, so Section 25 talks about what happens right after electing the members of the board. Under Section 25, within 30 days after the election of the directors, trustees, and officers, the secretary or any other officer of the corporation shall submit to the commission the names, nationality, shareholdings, and residence address of these people elected. Okay, so what happens if there is no election held? For example, there is no quorum, or say, for example, the election was not actually did not even continue in the first place. What will happen is that there must be a report of such fact, the fact of non-holding of the elections, and that 30 days starts from the original scheduled date. That report shall also include the new date, and the new date cannot be, kumbaga, the postponement cannot be indefinite. There must already be a re-election date set. Put loosely, re-election. And that is within 60 days from this original election date. What if, say for example, no new date is designated under paragraph 3, a stockholder, member, director, or trustee can apply with the SEC, but the SEC must first verify that application if the non-holding of the election is unjustified, and then the SEC may later issue summarily an order that an election be held. So whatever powers that an SEC may have, aside from issuing an order, are those stated under the last sentence of the 3rd paragraph. The second to the last paragraph, or the 4th paragraph, talks about an emergency quorum. Why is it an emergency quorum? If you remember, the manner of elections, just under Section 23, is that the vote must be by a majority vote of the outstanding capital stock. Here, under paragraph 4, what is required is the majority of the shares of stock represented at such meeting and entitled to vote. Not anymore majority of the entire outstanding shares, no? So this is to ensure that there will be no prolonged tenure of holdover directors or officers. How about the last paragraph? The last paragraph talks about a vacancy. If there is a vacancy caused by death, resignation, or any other manner for a director, trustee, or stockholder or officer, the secretary of the corporation shall actually inform the SEC within 7 days of such fact, and notice must be in writing. If it's not the secretary, then it can be the director, trustee, or officer of the corporation. Before, under the previous corporation code, the heirs of the deceased director had the obligation to inform. That's not true in the revised corporation code anymore. And actually, it was better that it was removed. Why? Because the heirs are actually not under the jurisdiction of the SEC. It's really more the responsibility of the officers. That way, they can actually be sanctioned if they fail to inform the SEC within 7 days. So sections 23 and 25 are actually both for third-party protection. And this is so that those dealing with the corporation know the facts concerning the business. So they are also properly informed of the corporation's organizational operational status. Where can these information be found? Normally, the names of the directors, trustees, and officers are normally stated in the GIS, or the General Information Sheet, which I'm sure you already know from your basic accounting. The GIS indicates who and who is not a corporate officer, director, or stockholder. Although sometimes the GIS can be subject to stronger proof if the entries therein are questioned. For most cases, like in the Supreme Court, if they usually refer to the GIS to determine if that person is really a director, and in relation to that director's authority to file cases on behalf of the corporation. How about if, for example, there is a vacancy and a new director, trustee, or officer is elected? Then the corporate secretary must submit an amended GIS within 30 calendar days from such change. And that's actually from an SEC memorandum circular, not from the revised corporation code. Now that we've already discussed the qualification, disqualification, and the manner of electing the members of the board, let's now move forward and talk about how much they can receive. This is covered by Section 29, Compensation of Directors or Trustees. So the first paragraph states, in the absence of any provision in the bylaws fixing their compensation, the default would be that the directors or trustees shall not receive any compensation in their capacity as such, except for reasonable per diems. Provided, however, that the stockholders representing at least a majority of the outstanding capital stock, or majority of the members, may grant directors or trustees with compensation and approve the amount thereof at a regular or special meeting. So, the first thing to point out would be that the default is directors and trustees cannot receive compensation because they are expected to render their services gratuitously since they have a personal stake in the outcome of the corporation. Two, it can be fixed in the bylaws. The compensation can be fixed in the bylaws. And three, even without a provision in the bylaws, the stockholders can still grant compensation as long as there is a regular or general meeting for that purpose where a majority of these stockholders or trustees vote for the grant of such compensation. Now, I just want you to note that there is a difference between compensation and per diems. Per diem is limited to a pay for a day's service. They are allowances and they are not compensation. So when you talk about compensation, it includes salaries, remunerations, bonuses, gifts, or any incentive for services rendered. These may include, say, in cases where the board of directors takes out an insurance policy for the directors, where the beneficiaries are the directors themselves. So the annual payments made on the insurance are actually considered as bonuses to the directors, because they if the policy ends, then they will receive the full payout. Another bonus would be Christmas gifts yan. So what about when it comes to per diems? Per diems are actually not fixed. So 1,000 pesos a day is perfectly fine. It can be increased or decreased depending on the circumstances. The default under Section 29, where they are not allowed to receive compensation, presupposes that these directors or trustees do not serve in any other capacity. Because directors can also be officers. Directors can also be employees of the corporation. The second paragraph talks about the limit. In no case shall the total yearly compensation of directors exceed 10% of the net income before income tax of the corporation during the preceding year. What does it mean when you say preceding year? It does not mean, for example, let me give a year, no? Say I am a director of a corporation in 2021, this year. I can if I were to be given compensation for my services, then I can get compensation so long as it is not over 10% of the net income before tax for 2021, not for 2020. Yeah, so that's what you mean by preceding year. Kasi it might cause some confusion. You might think, since I am a director in 2021, then the limit must be applied at 10% of income before tax in the previous year, preceding. No, it has to be in the year that the director is actually serving as such. Why would then the law state preceding year? If you look at it, it's because the directors and or trustees compensation reports, along with the reports on the financial statements, are normally present to the stockholders and submitted to the SEC on the year after. So in this case, it's usually presented to the stockholders during the 2022 annual stockholders meeting. That's why the provision there states preceding year. This limitation is intended for the protection of creditors, current and potential investors. How about, since you already talked about the compensation and the limit that must be 10% of income before tax, then the expense would be recorded or recognized on the period it was incurred. So in my case, in 2021 as well. This section refers to also pertains to trustees. So while members of non-stock non-profit corporations are not supposed to receive part of the income of the corporation, they may be given compensation. That is, if they actually render services to the corporation. Directors or trustees shall not participate in the determination of their own per diems or compensation. And this is reasonable and logical because there would be, syempre, there would be the desire to increase your own per diem or compensation. And lastly, corporations vested with public interest shall submit to their shareholders and the commission an annual report of the total compensation of each of their directors or trustees. This last paragraph pertains only to corporations vested with public interest. However, if you look at section 49, letter I, let me just write that here. At every regular special meeting, one of the things that the corporation must endeavor to present to its stockholders is what we call the director or trustee compensation report. For corporations vested with public interest, there is the added requirement here under the last paragraph to submit it to the commission. And this one, submitting it to the commission, is actually under section 177, number 1. So for those of you who would want to check, just go over the CODAL. Some other points before we move on. The compensation of officers is not part of section 29, okay? This only talks about compensation of directors or trustees. Therefore, the board may fix the compensation of officers in a board resolution. The salaries of officers are likewise not covered by the 10% limit under paragraph 2. The only requirement when the board fixes the compensation or the salary of officers is that it is reasonable. Much like how per diems must only be reasonable. There's no particular formula as to how to compute per diems as long as it's reasonable. So what is reasonable? Well, it would depend on the circumstances of the case. What if the ability to fix the salary, compensation, or per diems is abused? The stockholders are not without remedy. They can always file a derivative suit. or a stockholders or members suit, because this is actually a breach of a director's loyalty, because they're looking after their own interest first before the corporation's interest. Take note, when I say it's a breach of the director's loyalty, this is different from disloyalty under section 33, which we will discuss in a few minutes. Now that I've already mentioned corporate officers when we were talking about the remuneration for members of the board, we shall define what corporate officers are, and these are under section 24. Under section 24, there are three named particularly under the law: a president, who must be a director; a treasurer, who must be a resident of the Philippines; and a secretary, who must be a citizen and resident of the Philippines. So please pardon my typographical error on the word Philippines. Those three are called statutory corporate officers. Other officers that may be provided under the bylaws are corporate officers lang, not statutory. If you look at the next sentence, if the corporation is vested with public interest, the board shall also elect a compliance officer. These compliance officers are under SEC Memorandum Circular number 19-16. What do they do? Well, first of all, they make sure that the new board members of the board are knowledgeable of the charter, like the articles, the bylaws, among other things that they need to know. They monitor, review, and ensure the compliance by the corporation of the law and the rules and regulations. They report the matter to the board if they find any violations. They appear before the SEC if the SEC summons them. Normally, it's the compliance officer that is summoned by the SEC, because their duty really is to monitor and to report any violations, no? And they collaborate with other departments, and they identify possible areas of compliance. Okay, so they also ensure attendance by the board members and key officers to relevant trainings. I just wanted you to know that. The last sentence of the first paragraph refers to concurrent positions, meaning the same person may hold two or more positions concurrently, except that the president cannot be the secretary, and the president cannot be the treasurer, unless it's allowed by the code. So, for now, it's not yet allowed. It may be allowed later on if there is any amendment. I highly doubt that there will be, because of their functions. So, it would be difficult. Actually, it wouldn't be wise for the president also to be the secretary and the treasurer. The officer shall manage the corporation and perform such duties as may be provided in the bylaws and or as resolved by the board of directors. So the last paragraph is actually new, and it refers to the corporate governance principle. So how do we elect the members of the board? If you cross-refer this to Section 52 of the Revised Corporation Code, I'll just place it here, Section 52. They must be elected by majority of all the members of the board, not a majority of the members present. So just take note of that. Later on, when we go to Section 52, when it comes to regular and special meetings of the directors, it states here, unless the articles or bylaws provides for a greater majority, a majority of the directors shall constitute a quorum, and every decision reached by at least a majority of constituting a quorum is allowed, except for the election of officers, which shall require the vote of a majority of all the members of the board. So, there. Just take note of that. How about the other officers that are not stated in Section 24? You will see them under Section 62 of the Revised Corporation Code. They mention a vice president and an assistant secretary. Although the vice president and the assistant secretary are mentioned under Section 62, since they are not statutory corporate officers, they need not be immediately elected. Articles of incorporation and bylaws may create other corporate offices like chairman of the board, general manager, auditor, comptroller, and you've heard of these positions. These may be added later on. What is the term of office of these officers? Implicitly, meaning it does not really stated under the law, it's not clearly stated, but it can be implied that the position is just for 1 year. Why is that? Because the election of directors is during the annual stockholders meeting. So it is clear that the officers to be elected by a majority of all the board members will be after the board of directors is constituted. Okay. For those of you who plan to take up law, or for, I don't know if this ever is going to appear in the exams, there is actually a fine line as to whether a person is a corporate officer or an employee. If you are to add a position under the bylaws or the articles of incorporation, it must be expressly mentioned that the position is a corporate office. Because otherwise, it would mean that that person is just an employee. So the mere designation as a high-ranking employee is not enough to be considered a corporate officer. It is not enough also that the bylaws merely empowers the board of directors to create additional offices. So the bylaws cannot say, and other corporate officers as the board may deem sufficient. That's too vague. It has to be exact. So similar to statutory corporate officers where they may have concurrent positions, a corporate officer can also have a dual role, not just concurrent position, dual role of officer and employee. So for example, a corporate secretary may act as a managerial employee. That's allowed. So because the office must be expressly stated in the bylaws as a corporate office, the assistant vice president is not necessarily a corporate officer if it's not stated in the bylaws. You'd ask, if the particular office is not stated under the bylaws, does that mean that the board of directors are not allowed to appoint people? The answer is no. The board may still appoint, but these appointees are not corporate officers within the meaning of Section 24. So they are not empowered to exercise functions of the corporate office except those functions lawfully delegated to them. If a person is a corporate officer, his removal will be under the jurisdiction of the regional trial court. Either his removal or his appointment, his qualifications to the office are subject to the jurisdiction of the regional trial court. Whereas, and it's considered an intra-corporate dispute. Whereas if the person appointed by the board is not a corporate officer, then he or she would be an employee subject to labor laws and will be under the jurisdiction of the National Labor Relations Commission. The board may likewise delegate other duties to officers through board resolutions, such as the filing of a case, entering into contracts or compromise, ganyan. Now let's go to the statutory corporate officers under letters A, B, and C of Section 24. The first is the president. There can be only one. Why? Because if you look at it, letter A, president, meaning in the singular form. The same can be said about a treasurer and secretary. There can only be one. Because the corporate officers are not employees, they are not covered by the statutory retirement age of 65 now. They can actually serve for as long as they can. That's why if you watch Korean novelas or Filipino novelas or actually any novela, you would see that the president is usually the patriarch and super tanda na because there's no retirement age. They have different duties. If I may just dictate the provisions, the duties of the president are seen under Section 27, Section 52, Section 53, 62, 74, 129, 77, and 135. Yan. So, these are the president's order to the secretary to call a special meeting of the stockholders or members for removing directors. Another one will be to call for a special meeting of the board at any time as provided in the bylaws. Under Section 53 refers to presiding the meetings. unless the bylaws provide otherwise. As this is in the case where this is in cases where there is the chairman is absent. Under Section 62, to sign certificates of stock representing shares. Under Section 74 and 129, refers to the certification under oath of the financial statements if the total assets or liabilities of the corporation are less than 600,000. Under Section 77, to sign the merger, articles of merger or consolidation. Under Section 129, in particular, for a one-person corporation, to prepare and sign explanations or comments on every qualification, reservation, or adverse remark or disclaimer made by the auditor in the latter's report. And under Section 135, the President can sign the verification of a petition for dissolution of the corporation. So we just placed it all, we just enumerated them for easy reference. So the President is often given general supervision and control over corporate operations. He or she has no inherent power to act for the corporation, but they have certain limited powers. As long as these are in the usual and ordinary business of the corporation. So the President normally possesses the power to enter into a contract, and that the habit of acting in similar matters, that's allowed as long as a company had authorized, or even if they did not authorize, they later on recognize or ratify the President's acts. So a person dealing with an entity dealing with the President is entitled to assume that the President has authority to enter for and on behalf of the corporation. Now, as I mentioned a while ago, if I may just digress a little bit, the Vice President under Section 62 and 77 are recognized. The bylaws ordinarily assign to the Vice President the duty of succession. So, which is usually when the President is absent or disabled, much like the Vice President of our country, diba? Yeah. As to the Treasurer, under letter B, the Treasurer normally takes care of the funds of the corporation. The Treasurer is the custodian with authority to disburse funds in proper cases. The Treasurer is authorized to receive funds, issue receipts, and keep money. And there shall be only one Treasurer, as I've mentioned already. The functions of the Treasurer would include, under Section 14, to sign the Articles of Incorporation and certify the information under the 7th and 8th clause. So just please look at the form of the articles under the Revised Corporation Code. Number 2, the Treasurer must execute a sworn statement in cases of increase of authorized capital stock under Section 37. And the Treasurer must certify under oath the financial statements if the total assets or liabilities are less than 600,000 pesos. And this is under Section 74, 129, and 177. Let's move on to the Secretary. The Secretary must be a resident citizen. There can only be one. And the position is especially recognized. The Assistant Secretary is especially recognized under Section 62 and 77 also. I just want to add that. The Corporate Secretary cannot be a foreigner because it says here that must be a citizen. Therefore, the Assistant Secretary cannot also be a foreigner. What cannot be done directly cannot be done indirectly. And you will hear that if you decide to go to law school. The Corporate Secretary need not be a lawyer, although normally they are. And they are duty-bound to keep corporate records and to make proper entries into the books. So their specific functions would be to maintain the stock and transfer book, to sign the certificates of stock also under Section 62. They are responsible for sending notices of meetings, both to the directors, trustees, and to the stockholders or members. And they prepare the written minutes of the board. There are also, marami to. The others would be to certify to the minutes, to issue certificates known as the SecCert or the Secretary Certificate, and the SecCert is evidence of any board resolution. To call meetings, as I've mentioned, under Section 27, this is for the removal. To certify under oath as to the amendment of the articles, the increase of corporate stock, the delegation of the power to amend or adopt bylaws and the articles of and they must certify also to the articles of merger, and these are under sections 15, 37, 47, and 77. The corporate secretary also countersigns the bylaws to be submitted and the resolution approving the dissolution of the corporation under sections 45, 134, and 135. They must also verify the petition for voluntary dissolution where the creditors are affected, and this is under sections 135. They must submit the report, the general information sheet in particular, to the SEC. This is under section 25. And they must submit a report to the SEC on the non-holding of elections as previously mentioned under the same section. What else? They must submit a report to the SEC within 7 days if a director or trustee or officer should die or resign or cease to hold office. They receive the written they receive a written objection of a director or officer to the issuance of watered stock under section 64, which we will talk about later on. They receive the written objection of a director to an action within the corporate powers taken at a meeting held without proper call or notice in a closed corporation. And this is under section 100. Ay, tama ba? Section 100. The SEC, in a memorandum circular in 2013, imposed an additional obligation aside from the ones I mentioned, that is to monitor and observe compliance with the foreign ownership requirement. And that duty under the SEC memorandum circular cannot be delegated by the corporate secretary, without the express authority of the board of directors or trustees. So the concept of a board chairman and his functions as executive vary widely, depending on the different companies. The chairman may be concurrently the president and may be designated as the CEO of the corporation. In other corporations, they may be the president, who shall be the chief executive officer, and a chairman whose functions relate to presiding at meetings. And if a chairman is only designated as a chairman for purposes of presiding in the meetings, they are technically not an executive. If you look at the first paragraph that gives an exception as to concurrent positions, this is not the only limitation on concurrent positions. Incompatible positions obviously cannot be held by the same person. For example, an internal auditor cannot be the external auditor of the company. And a person cannot be a chairman and a vice chairman, because the vice chairman is just really there to take the place of the chairman in the chairman's absence or incapacity. It is also possible for a person to have the dual role of officer and employee, and I've already mentioned that previously. Other restrictions under the anti-dummy law. Foreigners cannot be officers in wholly nationalized or partly nationalized corporations. They cannot also be directors in wholly nationalized activities. So there's a difference. If ever the foreigner is elected as a director in a partly nationalized activity, it will be allowed as long as it complies with the equity participation allowed therein. So for example, if foreign participation is allowed up to 40%, then the number of foreigner directors must not exceed 40% of the entire board as well. What is the authority of these corporate officers? In the absence of a specific provision of law, the corporate officers and other agents of the corporation can act for the corporation only if authorized by the board or by the bylaws. The general principles of agency govern, subject to the provisions in the articles of incorporation, the bylaws, or relevant provisions of the law. A special power of attorney is necessary to convey or create real rights. Okay, so when it comes to real rights, like real property, although the corporate officer is assumed to be an agent without the need of a written authority, when it comes to real rights, they do need a special power of attorney. So what are the actions of the corporate officers that can bind the corporation? These are powers in the usual course of the particular business or incidental to the business of the corporation. Powers that are implied. Those that are added by custom or usage. So if it's normally the act of an agent, over time it will be recognized and it is actually it is binding on the corporation. And apparent powers as the corporation has caused a person dealing with the officer, meaning ostensible authority. The corporation made it appear that the officer has authority to do a certain act. So if the bylaws provides for specific powers of an officer, they need not secure a separate resolution from the board. Now, with respect to summons are directives by the court for a particular entity to appear before the court during trial. The rules of court have particular requirements, not just, although officers are agents, so if you look at it, they can be served legal processes like summons. The rules of court particularly give a list of who may accept summons. So for domestic corporations, it can only be the president, general manager, corporate secretary, treasurer, or in-house counsel, or their secretaries. I just want you to know that as well, although that's not really required because that's outside of Act Reg 1 if you're gonna be strict about it. There are also cases when unwritten authority is necessary to authorize an officer aside from real rights. So, for example, the power to borrow money is usually one of the cases where the corporate officers need a special power of attorney. What is the implied authority that I just mentioned? These are necessary or appropriate to the conduct of business. It would depend on the type of business that you're in. The corporate acts of officers within the scope of their authority are binding on the corporation. What happens if they exceed their authority? Is all lost? The answer is no. Their actions can still bind the corporation as long as there is ratification or as long as the corporation is stopped from disclaiming them. So what are these? Like when they accept benefits, when the corporation accepts the benefits out of that officer's acts, then that's ratification. This is when you say ratification, they are adopting or giving sanction to the act. Okay, however, silence by the corporation does not necessarily mean that they approve or ratify the same. Meaning, there are times that when the corporation is silent or the board is silent as to an officer's acts, it will bind the corporation. When? Usually when there's no other acceptable explanation as to why the board has been silent. This assumes that they already know about the corporate officer's acts. So if you remember under your civil code before, under the agency of Estopel, under Article 1873, it applies also to corporations. So if you remember yung sa partnership by Estopel, it's the same lang din in corporations. So there another name for it, apparent authority or holding out theory, where the corporation knowingly permits or allows its officers to do acts within the scope of an apparent authority, not actual, apparent, and holds the officer out to the public as possessing that alleged power. Why would the corporation be bound by Estopel? It's not because of any contractual relationship really, but because of the actions of the board or the principal or the employer into misleading the public into believing that a relationship or authority actually exists for that corporate officer. What are de facto officers? De facto officers act under color of authority. They don't have real authority to act as such. So usually This is through an irregular or an informal election or appointment. Okay, so let me just reiterate the compensation of corporate officers. And I've mentioned this already in passing when I was discussing compensation of members of the board. Even without the provision in the bylaws, the compensation of corporate officers may be fixed by the board, and it is part of the business judgment rule. Let us now move on to the liabilities of directors, trustees, or officers, and these are under Section 30 of the Revised Corporation Code. So the operative words here are directors or trustees who willfully and knowingly vote for or assent to patently unlawful acts of the corporation, or who are guilty of gross negligence or bad faith, or acquire any personal or pecuniary interest, conflict of interest, no? They shall be liable jointly and severally, or otherwise what we call as solidary liability, for all damages resulting therefrom suffered by the corporation, its stockholders or members, and other persons. Paragraph 2 also talks about another type of conflict of interest. So, Section 30 here, we will be discussing also with Section 33 right after this, are intended to impose the exacting standards of fidelity on corporate officers and directors. As mentioned already, they owe a duty of loyalty. So, in particular, the duties of directors, trustees, and corporate officers are obedience, diligence, and loyalty. No, this is because directors have a fiduciary relationship with the corporation. Although they are not strictly trustees under the definition of the new civil code, they are sort of trustees of the corporation, no? When you say diligence, and this was already discussed in the midterms exams, diba, for partnership, what type of diligence is required for that? Here, the diligence required of directors is due care, utmost good faith in the management of corporate affairs, or what we call a reasonably prudent person. Yan. So that's the quantum or the amount of diligence required for them. There is a radical difference when a stockholder is voting strictly as a shareholder and when he or she is voting as a director, because when that person votes as a shareholder, he or she only represents himself, whereas if a board member votes, that member represents all the stockholders in his capacity as trustee, loosely put, as trustee of the stockholders. So if you look at Section 30, the requirement of bad faith or gross negligence is not the same as simple negligence or mistake, ha. They are not insurers and are not liable for errors of judgment or mistakes. This is covered by the business judgment rule so long as they are acting with reasonable diligence, care, and skill. So for example, the fact that a corporation suffered heavy losses does not make the directors personally liable. Although it is not required under the laws that the directors or officers personally conduct an audit, part of their due diligence is that they are familiar with the financial status of the corporation, especially since Section 3 of SEC Memorandum Circular Number 6 Series of 2008 requires either the President or CEO and Treasurer or CFO to sign a management representation. Now, since you are accountancy majors, you will know that aside from the independent auditor, the annual financial statements are also signed by the president, diba? The importance of loyalty becomes more important when ownership and management are separate, and this is usually the case of large corporations. A director, as a fiduciary, cannot, by the use of the corporate device, avail him or herself of privileges normally permitted to outsiders. Diba? So he cannot utilize his inside information and his strategic position for his own benefit. So this, aside from this broad duty of loyalty, you will see in different parts of the Revised Corporation Code provisions that that implement this duty, and that is one, self-dealing directors under Section 31, two, contracts between corporations interlocking and with interlocking directors, and that's Section 32. 3, the usurpation of the corporation business's opportunity, and we will discuss that here under this section and Section 33. 4, oppression of minority shareholders, and that is Section 27. If you remember, no, we will discuss that later. 5, conflict of interest under, and 5, conflict of interest under Section 30. So in addition to the duty of loyalty stated in those 5 circumstances, there are others as well, and this was discussed in another book. Say corporate properties are diverted without the authority for the personal benefit of directors. That's logical, that's common sense. Directors and officers acquire compensation for more than the fair value of their services. They provide false or deceptive information on which stockholders rely to their damage. Insider trading under the Securities Regulation Code, and acceptance of bribes, and the use of governance machinery to protect entrenchment in office. So their loyalty is not only to the corporation, but also to the stockholders and to creditors. So in one case by the Supreme Court, where the corporation is insolvent, its directors, who are its creditors, cannot secure to themselves any advantage or preference over other creditors. As a rule, although the directors and officers are not personally liable with a corporation, they become such by virtue of this section. No? As to criminal liability, in relation to Section 30, they are not criminally liable under Section 170 of this code. Why? Because to be criminally liable under Section 170, there must be a penal sanction expressly stated in this section, Section 30. So, since there's no statement under Section 30 that they will be criminally liable, then Section 170 will not apply. However, there are also other impositions of liability in relation to Section 30. And what is that? Under Section 171, if the offender is a corporation, the penalty may, at the discretion of the court, be imposed upon such corporation and or its directors, trustees, members, officers, or employees responsible for the violation. Also, Section 172, anyone who shall aid, abet, counsel, command, induce, or cause any violation of the revised corporation code or any rule, regulation, or order of the SEC shall be punished with a fine not exceeding that imposed on the principal offenders at the discretion of the court. Yeah, so, the liability of the directors, trustees, and officers under Section 30 can also extend to those who help them. So, when you talk about solidary liability here in this provision, it is not only under Section 30 where you will find the directors, trustees, or officers solidarily liable. There are also other circumstances. And these are, if I may just add it for so that it would be easier to remember solidary liability. Section 30, as I've mentioned. Section 64 on the issuance of watered stocks. When the director, trustee, or officer expressly or contractually agreed to be solidarily liable with the corporation, and when they are made liable by specific provisions of the law. So let me go over that very quickly. Under Section 30, patently unlawful acts. It is a patently unlawful act if it is declared unlawful by law. And that law imposes penalties for its commission. So, an act that is ultra vires or outside the authority of the director is not patently unlawful right away. Okay, so what's an example? Under the Labor Code, for illegal dismissal cases, those are patently unlawful acts. These are found under Article 287 and 288 of the Labor Code. What else? Syndicated estafa. That's under the revised penal code. Yeah. So another part here under Section 30 where you will see gross negligence or bad faith. Bad faith and fraud. Bad faith connotes a dishonest purpose. So it's synonymous with fraud because there is this intent to deceive or defraud others. So there must be clear and convincing evidence. How about gross negligence? It amounts to bad faith because when you say gross negligence, not gross, gross. Negligence means thoughtless disregard of consequences. I'll give you an example. The president and controlling stockholder of a corporation was made solidarily liable in a Supreme Court case when in a contract of loan, he was completely negligent because he did not inform new investors that the corporation already had difficulties receiving payments from borrowers. There was already formal insolvency proceedings. He did not know who took over when he resigned as president. He did not inform them if the investors got their money back because diba may insolvency proceedings. He did not say who else invested. He did not even know where the financial records are. He didn't even present his personal copy of the financial record. So, kumbaga, talagang he doesn't care. Yan, that gross negligence, he just doesn't care about what's gonna happen. Another case, the board members were made liable because they approved a credit line application for 2.5 billion pesos, knowing and despite the glaring signs that they would not be able to make good that obligation. What else? There's this other case, in the case of Sanchez versus Republic, where the president and the executive vice president failed to personally remit rentals and earnings to DEX, even if they were bound under contract. They didn't give an accountant to DEX either, and worse, they deposited the earnings and rentals in the bank account under the name of the executive vice president and the corporation's accountant. So Section 64, another case of personal and solidarity liability. We will go over that later. And if you remember our discussion under watered stocks, these are stocks issued for less than par value. Yung instance where they are contractually where they agree under contract to be solidarity liable is self-explanatory. And let's go to the fourth one, where they are made liable under a specific provision of law. What is that? Under the SSS for unremitted SSS contributions, they are liable there. And before we move on to the disloyalty of directors under Section 33, note that directors and officers are the only ones personally liable if they are not authorized at all to perform the act or they somehow acted in excess of their authority. This Section 33 is different from piercing the veil of corporate fiction, which we have extensively discussed in a previous video. Why? Because it's not necessary to prove also complete dominance of the corporation. So we can move on now to Section 33. Section 33 talks about the disloyalty of a director only, not a trustee or an officer. Why? Because this talks about the doctrine of corporate opportunity. If you note, the reason why trustees are not included is because non-stock corporations generally do not engage in business, diba, for profit. Non-stock, it's non-profit nga eh. Yan. So, the law does not permit a director to seize the opportunity even if that director will use his or her own funds in the venture. So the prohibition under Section 33 does not apply if the action was made after the resignation of the director. Neither does it apply to cases when two related corporations are involved, even if there is interlocking directorship. So what is required here in order for a director not to be found guilty of disloyalty? Here, it is necessary for the director to take positive steps which show that the opportunity was brought before the corporation for its decision, whether to avail of it or not, and the corporation rejected it. In other words, there must be notice to the corporation, and that the corporation expressly said it will not avail of that opportunity. So the director, aside included in this duty to notify the corporation, must inform the corporation that of any information related thereto, no? So it cannot be just a mere offer. The corporation must be given a reasonable chance to undertake that business opportunity. Normally, mere offer by the director to the corporation to undertake the business and the lack of funds are not sufficient justification for taking advantage of this corporate opportunity by the director. Because the director is involved in raising the necessary funds that the corporation needs. It's his duty. So he can't say, oh, the corporation doesn't have money, so I'll just take it myself. Kumbaga, what you're doing is that the director is putting him or herself first. So when I mentioned that trustees and officers are not covered, they are nevertheless prevented from unduly taking corporate opportunity. Yan. So just in case that it happens, no? And you can see this even if it's not under Section 33, it's under the new Civil Code because they are agents. Diba? Trustees are also agents of the corporation. So they cannot take on any venture that is in conflict with the corporation's undertaking. In cases where the trustee is disloyal, so to speak, since it's not under Section 33, the ratification of a trustees act does not need the stockholders' 2/3 votes, as you can see here under Section 33. The ratification of the board of directors is sufficient. So that's the difference between trustees and directors. Here, let me read you some instances. Mr. X, a director of Corporation A, is a director of Corporation B. Mr. X acquired for Corporation B, not for himself, a business opportunity identical to the business of Corporation A. He could not give the business opportunity to Corporation A allegedly because Corporation A's policies strongly impede its chances of winning that business. Is there a violation of Section 33? And this was an SEC opinion, no? Sabi ng SEC, if it is true that Corporation A cannot engage competitively in that business because of its policies, then it may not be said that by delivering the opportunity to B, Mr. X will be disloyal to Corporation A. Section 31 refers to corporate dealings or what we call self-dealings also. This contemplates a contract with the corporation and either one or more of its directors, trustees, officers, or the directors, trustees, or officers' spouses and relatives within the fourth civil degree of consanguinity or affinity. By fourth civil degree of consanguinity or affinity, we count that, I don't know if you've discussed this already in your previous law classes, but you count that by, say, drawing a family tree between the director, trustee, or officer and the relative, and then you count up to the nearest common ascendant before counting down. Okay, let me give you an example. So in an example where the director here, when you say fourth civil degree of consanguinity by blood or affinity by marriage, so it can also refer to your in-laws. If, for example, here is the director, when you say fourth level, you will have to go up to the parents. That's 1. Then you go up to the grandparents. That's 2. Then you go down to the aunt or uncle of the director, That's 3. And then you go down to the cousin, first cousin. That is 4. This is not the only instance of a fourth degree of consanguinity or affinity. So when I say affinity, it means it can be the first cousin of the director's spouse. That's included. Another instance would be where the director, You go up to the parent. I'll just put P. You go down to the sibling. Doesn't have to be the grandparent. So at least you get the idea of how we're counting for, diba? You go down to the niece. How do you spell niece? I before E except after C. Am I right? Niece or nephew. That's 3. And then you go to the grand niece. Sorry, I'm not so good with this. Or nephew. That's another instance of 4th degree of consanguinity or affinity. In other words, if I may repeat, you will just go up to the nearest ascendant before going down. And then you count how many steps that takes. So contracts between the corporation and these people that I have just enumerated are voidable. So they are valid until they are sought to be annulled at the option of the corporation, unless all of the following conditions here under A to E are present. These are the conditions to make the contract completely valid. So if these conditions are present, then it is not voidable anymore, ha? So please read A to E by yourself, okay? Where any 2 of the first 3 conditions, so there's a bit of a misnomer here. When you say first 3 conditions, you're including letter C. It says here, when any of the first 3 conditions set forth is absent, in case of a contract with a director or trustee, such may be ratified by the vote of the stockholders representing at least 2/3 of the outstanding capital stock or members, provided, meaning part of this requirement under the last paragraph, that full disclosure of the adverse interest of the directors or trustee involved is made. There's a full disclosure at the meeting, and the contract is fair and reasonable under the circumstances. What does it mean? There is an error when you said first 3 conditions, because when you said first 3, it means that letter C need not be present, that the contract is fair and reasonable. That's required right there. Okay, so the last paragraph talks about the safe harbor provision. So when you read section 31, just read it with the last paragraph of section 52. And this talks about the director's obligation to recuse from voting if that director or trustee has potential interest in any related party transaction. You also read this with section 49J, where related party transactions or self-dealings are required to be disclosed. So self-dealing is discouraged because it is thought that there can be no real bargaining when it comes to dealings between the corporation and the person stated there. However, there's also a view during the deliberations of the previous corporation code is that these types of contracts are not necessarily undesirable. There are occasions where a director or an officer decides to enter into a contract with the corporation and agrees to more beneficial terms precisely because of their trust relationship. So in these types of cases, it is not required that there is intent to defraud or that the contract results in corporate losses. Actual damage is not required so long as the requirements you see there are complied with. So what do you mean when you say fair and reasonable? It means arm's length transaction, and I'm sure as accountants you already know this. The burden is on the self-dealing director to prove that it is fair and reasonable. It encompasses actually more than just money or consideration, no? It can also include where instances where the value to the corporation depending on the corporation's needs and the scope of its business. Yan. So that's included when you consider what is fair and reasonable. Under this rule, even if the self-dealing director did not vote, the contract is still voidable if the director did not disclose the consequences of the contract. As you can see, it is required under the very last sentence that full disclosure is made. Let me give you an example under another book that I'm reading. In Prime White Cement Corporation versus Intermediate Appellate Court, The dealership agreement was neither fair nor reasonable, as Prime White Cement was to sell and supply to a director 20,000 bags of white cement per month for 5 years. So if you think about it, you'll say, why is it not fair? It doesn't say that they're selling it at a loss. Here, the Supreme Court held that the director is a businessman himself and must have known, or at least presumed to know, that prices of commodities in general and wine cement in particular were not stable and expected to rise. So although it is an arm's length transaction now because the contract is for 5 years, it's possible that the price of cement can significantly go up. But the corporation will not have a choice but to sell it to the director at the price stated in the contract. So that's one of the instances when I was saying that it's not necessary that you just focus on the consideration paid when you're talking about what is fair and reasonable. So Section 32, contracts with interlocking directors. So just read the provision. Interlocking directorship by itself is not prohibited under the Corporation Code. The contract is valid if the interests of the interlocking director in the corporations involved are both substantial or are both nominal. Because the one stated here under Section 32 is that the interest of the interlocking director in one corporation is substantial and in the other is merely nominal. The exception under Section 32 is when the contract is fraudulent or not fair and reasonable. So in that case, the contract is voidable at the option of the corporation that is the victim of this fraud or unfairness. It may also be annulled under circumstances under the Civil Code for unavoidable contracts. If the interest of the interlocking director in one corporation is nominal and substantial in the other, a contract between two corporations shall be voidable at the instance of the corporation where the interlocking director has nominal interest, unless the following conditions are present, in which case, if the conditions are present, the contract is valid. 1. The presence of the interlocking director in the board meeting was not necessary, similar to 31, no? 2. The vote of such director was not necessary. And 3. The contract is fair and reasonable under the circumstances. So in the absence of the first two circumstances about the presence of the director and the vote, the contract can be ratified by the vote of the stockholders representing 2/3. As long as, again, there is full disclosure and it's fair and reasonable under the circumstances. So that's the similarity between 31 and 32. Section 32 applies if the contract results in prejudice to one of the corporations. So be careful, this rule does not apply if the corporation allegedly prejudiced is a third party and not one of the corporations with interlocking directors. Let's talk about removal of the directors or trustees under Section 27. You will read it here. Any director or trustee may be removed by a vote of the stockholders representing 2/3 of outstanding, or in case of non-stock by 2/3 of the members, provided that it shall take place at a regular meeting or a special meeting called for the purpose. And whether it's regular or special meeting, there must be notice of the intent to propose the removal of such director. So how will a special meeting occur? It must be called by the secretary on order of the president or upon written demand by the stockholders representing at least a majority of the outstanding capital stock or majority of the members entitled to vote. So be careful between that 2/3 and that majority vote shift. If there's no secretary, or if the secretary refuses or fails to call the meeting, the stockholders may directly demand the stockholder or member of the corporation signing the demand may call for the meeting directly addressing the stockholders or members. It must also be published or by written notice prescribed in this code. Okay, what are the grounds for removal? It can be with or without cause, provided that removal without cause may not be used to deprive minority stockholders or members of the right of representation, which they may be entitled to under Section 23 of this code. What does this mean? A director can be removed with or without cause, no qualification except for one. if the removal is without cause, it should be ensured that the director being removed is not will not affect the right of minority stockholders. How? For example, that director is the only director voted by the minority. If you remember, di ba, minority stockholders don't have much percentage of shares. So their votes are not significant to be able to put a director in the a member into the board of directors unless they do cumulative voting, di ba? In some circumstances. In those cases, usually they're only able to accumulate, say, one or two. So, if they have one or two and then you remove that pa, effectively, you're removing them of their right of representation. Okay. The commission shall, motu proprio or upon verified complaint, motu proprio meaning on their own, after due notice and hearing, order the removal of a director or trustee, not officer. So, the SEC cannot remove officers, ha. Despite the disqualification, so, or whose disqualification arose or discovered subsequent to an election. The removal of a disqualified director shall be without prejudice to other sanctions that the Commission may impose on the board who, with knowledge of the disqualification, failed to remove such director. So, if you remember, Section 170. Yan. So, this right is called a motion. A-M-O-T-I-O-N. Stockholders kasi have the traditional inherent power to remove a director for cause. That's what is defined under a motion. What happens when they are removed? The stockholders, members may elect the removed director's or trustee's replacement during the same meeting, and you will see that under Section 28. A special meeting to remove a director shall be void if it was called by an unauthorized committee or not by the secretary as provided for under the previous section, Section 27. And the defect cannot be ratified. So, for example, if there is an oversight committee, the oversight committee is neither empowered by law nor bylaws to call a meeting and subsequent ratification made by the stockholders. Any subsequent ratification made by the stockholders will not cure that defect. And this was actually a case, Bernas versus Cinco, in where the Makati Sports Club had an oversight committee that called a meeting to remove a particular group, the Bernas group. So the removal, I'll just go back quickly, the removal under Section 27 should be distinguished from ouster because of disqualification. There is no need to follow the procedure of removal under Section 27 if the director is disqualified. Because, by operation of law, such director is disqualified to act, thereby creating a vacancy in the board. Mere declaration of disqualification is sufficient. Generally, and be careful, the removal of the director does not result in the transfer of his shares. The removed director remains a stockholder. So I mentioned earlier that the SEC cannot remove corporate officers, just directors and trustees. Why? Because the removal of corporate officers is a corporate act. Okay. I'll move back to Section 28. So it talks about any vacancy occurring other than removal or by expiration of term. Why can the vacancy may be filled by the vote of at least majority of the remaining stockholders or trustees if that board still constitutes a quorum. Otherwise, it must be filled by the stockholders in a regular special meeting called for the purpose. Why cannot the board fill in the vote of directors who were removed or whose term has expired? Number one, because if the term has expired, it means 1 year has already lapsed. Obviously, it is the right of the stockholders to vote for their directors. How about removal? Usually, syempre, to prevent directors from removing who they like and then replacing it with someone who they do like. When the vacancy is due to term expiration, the election shall be held no later than the day of such expiration at a meeting called for the purpose. It's already there in the second paragraph. So the requirements are there, just read it yourself. And the replacement director or trustee shall serve only for the unexpired term. Okay. The third paragraph, the one starting with the word however, sorry, I was not able to differentiate. And this paragraph refers to emergency board. So just read that first and I'll just discuss some points in the interest of time. Vacancy is the operative fact that justifies the election or appointment of a replacement. Thus, an election to choose replacements cannot be allowed if the board is still complete. For example, the the term of a director will end in February. You must vote after the day after the expiration of the term, not today, not in January. Since with the where the stockholders or members must replace or elect the director if the vacancy is due to removal, expiration of term, a ground other than removal or expiration of term like death, resignation, or abandonment, where the remaining stockholders do not constitute a quorum, and an increase in the number of directors. So there are four. The provision allowing the board of directors to appoint a replacement if there is a quorum is not mandatory, ha. That's why if you look at it, it only uses the word may. Yeah, may be filled. So a vacancy may occur if the director abandoned his position. For example, the director accepts a position that is incompatible with the directorship or which will render that director physically incapable of performing duties as a director. Say, for example, the director was assigned and accepts an assignment to work, say, in another country. And, yeah. Diba? So, he cannot be here. The bylaws may provide for the procedure for filling up the vacancy as well. But these provisions must be consistent with the other provisions of the Revised Corporation Code. So, there can be a case where the bylaws may provide that it's the stockholders that must fill the vacancy and not the remaining board constituting a quorum. This is different from Section 23, which we discussed earlier. Okay. So, since we say expiration of term, if the director is sitting in a holdover capacity and that person resigns, the vacancy cannot be filled by the remaining holdover directors because it states at the first sentence, any vacancy except upon the expiration of the term. There's no more term to speak of. Remember, term is different from tenure. So the emergency board under Section 3 and Section 28 here is different from the executive committee under Section 34. The emergency board is only valid to perform temporarily a particular act to prevent grave, substantial, and irreparable loss or damage to the corporation. So, what is an executive committee under Section 34? Part 1 refers to the executive committee. If the bylaws so provide, that's important. The board may create an executive committee. If it's not in the bylaws, it's not allowed. And there must be at least 3 directors. What does it mean? There can be 3 directors and 2 non-directors, and they'll still compose an executive committee. Execom. Meaning, the execom need not all be directors. What else do you need to note in this provision? The word here under letter E is distribution of cash dividends, meaning they can declare dividends. Yan. Kasi the ones under letters A, B, and C refer to things that they cannot do. Paragraph number 2 is different. Paragraph 2 refers to board committees. This is actually a new provision. So these are not executive committees. Although Section 34 includes management committees in the title here, they are not statutorily defined under Section 34 if you've noticed. Neither is there any delineation as to its functions. So the execom is generally an agent of the board because it performs what is vested by law in the board of directors. A foreigner can be a member of the executive committee in proportion to the foreign shareholdings in the corporation. This was an SEC opinion. The executive committee is within the limits of its authority as powerful as the board as it actually performs certain duties of the board, and in effect, it is acting as the board itself. Take note of that. But despite this power by the executive committee, there is no undue abdication of the powers of the board. While the committee may manage the day-to-day operation of the business and the affairs shall be managed, and all corporate power shall be exercised under the ultimate direction of the board. The board cannot delegate the entire supervision and control of the corporation to an executive committee. So, because of this power of the executive committee, as I mentioned, it is acting as the board itself. Its decisions are not subject to appeal to the board. They are valid and unappealable. However, the board may ratify the resolution if the executive committee's resolution is invalid. Okay, the majority vote requirement under Section 34 shall be interpreted to mean majority of all committee members regardless of the classification as to whether they are members, directors, or non-directors. If the executive committee was not validly constituted, the members thereof may be considered de facto officers. So what about board committees under the second paragraph? They are created to give assistance in the performance of the board's functions. Their actions therefore require ratification and confirmation. Yan. So for example, under the Code of Corporate Governance, corporations that are covered under the Code of Corporate Governance are required to create an audit committee. Or the board usually also creates a nominations committee or a remuneration or compensation committee to assist in its corporate governance. Yeah. So that is Title 3, and I'll see you in Title 4.